All right, picture this. You've been dreaming of it, planning it, maybe even saving for years. It's the trip of a lifetime, maybe something huge like the FIFA World Cup. You got the tickets, the destination's all set, you're buzzing with excitement. It's all planned out, right? But then, what happens when those plans just hit a completely unexpected wall? What if that visa application, the one you thought was pretty straightforward, gets denied, and suddenly those dreams are just on hold? It's a real gut punch. Today, we're taking a deep dive into a really fascinating and honestly a bit heartbreaking story about a visa denial that actually happened. It comes from a Reddit user, so we get this unique firsthand look. It offers some really crucial insights into the B1, B2 visa process, especially if you've got global travel plans yourself.
Absolutely. Our mission here is to kind of unpack this person's experience. We want to explore why these denials happen, specifically under Section 214B of the U.S. Immigration and Nationality Act. And most importantly, figure out the key takeaways, actionable steps for anyone applying in the future. What's really interesting is how seemingly small details, or maybe how you frame them, can make such a huge difference.
Okay, let's get into the story then. So our applicant, he's a 31-year-old guy from India. He's self-employed, runs a video marketing firm that's GST registered, so like an official registered business. He and his wife, who's 29, were planning this trip to the U.S. July 5th to July 15th, 2026. And the whole point, to experience the FIFA World Cup in Seattle and LA, I mean, that sounds amazing, right? A real dream trip.
It absolutely does. And it's tied to a specific event with clear dates. You'd think that makes the purpose of the visit really clear, really compelling.
You would think. But this is where things took a strange turn. According to the applicant, the actual visa interview was super brief, almost like surface level. The consular officer, a woman maybe in her mid-30s or 40s, apparently greeted them, asked for passports, then boom, straight into routine questions. Finances, job, how long they plan to stay. But all their excitement about FIFA, the detailed plans they probably had, it seemed like that was just bypassed. Ignored almost.
Yeah, that's really striking. Bypassing the enthusiasm, the specifics of the event itself.
It is. So does that brevity, that quick pace tell us something? Was the officer just being efficient, or did she maybe decide something really early on?
Well, that's a great question. Look, while your enthusiasm for the trip is genuine, and it's important to you, the consular officer's main job isn't really about sharing your excitement. Their core function is risk assessment. They're trained to look for potential intent to immigrate, not stay temporarily. So they focus on concrete ties, credible plans, things that prove you'll leave. Not so much the emotional aspect of the trip. A brief interview isn't automatically bad. It might just mean the officer quickly found or didn't find those crucial anchors they need to see. They have limited time, they need to make fast, informed calls.
Ah, okay. So they're not looking for your holiday itinerary, they're looking for proof you're coming back. And what's really interesting here is the money side of things. He mentioned having about 8 lakh rupees in his bank account, plus another 30 lakh in mutual funds. That's quite a bit of money. Significant financial stability.
It certainly sounds like it, yes. A substantial amount.
But even with all that financial backing, he still got denied. That part really surprises me.
It surprises a lot of people. Despite having what looked like solid financial proof, he received a standard 214B denial right after the fingerprinting.
Yeah.
It really challenges that common idea that just showing you have enough money is, the main thing.
Yeah.
Clearly, there's more to it.
Yeah, it definitely makes you think. And the applicant himself, reflecting on it later, he kind of reached his own conclusion. He felt maybe his self-employment status, plus maybe not clearly spelling out his ties to India. He used the phrase, emptied his case of persuasive anchors, like he didn't give them strong enough reasons to believe he'd return.
That's insightful self-reflection.
He even admitted later that maybe if he'd stressed his commitments back home, family stuff, work projects, maybe saying something like, look, I can't stay longer than 10 days because I have these responsibilities, that might have been stronger proof.
Exactly. That really brings us to the core issue, the intent to return.
So how do officers judge that? What's this legal principle they're working under?
Right, so this story perfectly highlights Section 214B of the Immigration and Nationality Act, the INA. And this is the absolute fundamental thing you have to grasp. The law presumes that every non-immigrant visa applicant actually intends to immigrate, to stay permanently, unless you, the applicant, can prove otherwise convincingly. The burden of proof is entirely on you.
Wow. Okay. So you're basically presumed guilty of wanting to stay. Until proven innocent, you have to actively overcome that assumption.
That's a good way to put it, yes. You have to proactively demonstrate non-immigrant intent. And officers look for 3 main things to establish that. First, strong home country ties. You need to show clear, robust connections back home. Things like, family you support, property you own, a stable job you have to get back to, maybe kids in school, or elderly parents you care for. These are the anchors.
So not just having a job, but maybe specific projects, owning a house, not just renting, dependents who really rely on you, things that make leaving long-term really difficult or impossible.
Precisely. Real, tangible commitments. Second, you need financial stability and a credible plan. Show you have enough money for the whole trip, not just the flight, and present a realistic, documented plan, what you'll do, how long you'll stay, why you're going. This shows you won't need public assistance and that your visit is temporary and legitimate.
Which, again, our applicant seemed to have covered with his savings, right?
He did, financially speaking. But the third factor is crucial: clear purpose and consistent responses. Your reason for travel needs to be unambiguous and believable for a temporary visit. And critically, how you answer questions in the interview matters. Be clear, be consistent, answer directly. That enthusiasm for FIFA. Great for you, but maybe not the core evidence the officer needed to establish you were definitely leaving afterwards. They want facts proving temporary intent.
Okay, so pulling this back to our applicant's story. Despite the strong finances, it sounds like he maybe fell short on proving those ties, that first point you mentioned.
That seems to be the likely issue and aligns with his own reflection. While the money was there, maybe he didn't effectively highlight other critical ties. Think about it. Ongoing business projects with deadlines. Did he mention those? Dependents back in India. A mortgage on a home. These are the kinds of things that really strengthen a B1, B2 case because they scream, I have to come back. It's not just having them. It's about articulating them effectively.
So it's about painting that picture clearly for the officer.
Exactly. Instead of just, I have family, maybe saying, my elderly parents live with me in Chennai and rely on me for daily support. Or, my marketing firm has contracts requiring my personal oversight, meaning I must return by July 16th. Specifics matter.
That makes such a difference. It's the why behind the tie, not just the tie itself. Okay, so this denial happens. It feels final, devastating, especially with the World Cup clock ticking. But you said it's not necessarily the end of the road.
That's right, and this is really important for people to hear. A 214B refusal isn't a permanent ban. It doesn't mean you can never travel to the U.S. There are definitely steps you can take.
Okay, good. So what are the options?
Well, the first and most common option is simply to reapply strategically. And the key word there is strategically. Don't just submit the same stuff again, hoping for a different officer. Review your first application. Where were the weak spots? What wasn't clear? Update it. If your circumstances have changed, maybe you bought property, had a child, got a promotion with more responsibility, highlight that. Show stronger ties. And yes, often a different officer will review it, and a better prepared case can absolutely lead to a different outcome.
Right. Learn from it, strengthen the weak points, and try again with a clearer picture. Makes sense. What else?
Second, consider seeking professional guidance. You could talk to immigration lawyers or consultants, maybe even former consular officers. There are services like UDTI, which came up in the source material, that specialize in this kind of thing. Getting professional insight can be really valuable. They understand the system from the inside out, can pinpoint weaknesses you might miss, and help you frame your case much more effectively next time.
Yeah, getting that expert eye on it could make a big difference, especially understanding the nuances.
Definitely. And the third thing, which ties into reapplying, is to really refine your interview responses and documentation. Practice how you explain things. Be crystal clear about how long you're staying, exactly why you're going, how it's funded, and crucially, your concrete reasons for returning home. Every document, every answer should reinforce that you're just visiting. Think about that presumption of immigrant intent and proactively provide evidence against it. Instead of just, I have a job, maybe my role requires me back for a major client presentation on date. Be specific. If it's family ties, explain the dependency clearly.
Wow. Okay, so this whole situation, the story, it really drives home that even if you feel well prepared, like our applicant with his business and savings, you can still hit this roadblock. It happens if you don't effectively show those strong home country ties and make your intentions crystal clear. It's about more than just having the money or a reason to go.
It really is. But the positive side is that with careful preparation, truly understanding that legal hurdle, you need to clear that 214B presumption and framing your case strategically. Reapplication absolutely can work. It can still unlock those World Cup dreams or whatever your travel plans might be. It just requires being thorough, strategic, and persuasive.
So I guess the big takeaway here is it's not enough just to have those strong ties back home. You absolutely have to articulate them clearly, convincingly, both on paper and in person. That proactive demonstration is key.
It really is. And, this deep dive, it reminds us that international travel, as exciting as it is, always has this layer of, well, legal and bureaucratic stuff to navigate. It kind of begs the question, doesn't it? Beyond the forms and the documents, how well do we really grasp the, let's say, unspoken rules or assumptions that govern how we move around the world? And how can we get better at navigating them?
That's a deep thought. And maybe for you listening, it's worth thinking about your own anchors. If you were applying for a visa tomorrow, what are the solid, compelling reasons you'd point to prove you're definitely coming back home? It's something to consider before you find yourself facing an unexpected hurdle on the way to your dream trip.